September?
Aye, sir.
Okay. That would be the motion for a questionnaire. Okay. All right. I'll need to probably set both of those for hearing, so to give all the other related and interested parties an opportunity to respond. When did you file your motions to restrict discovery and for the questionnaire? The questionnaire hasn't been filed yet. I understand that. It's coming. That's coming.
Monday.
No, questionnaire hasn't been filed.
No, the one for restrict.
Restrict is Monday.
Monday, Judge. It was filed Monday and served.
Okay.
Basically, we found a lot of information concerning one of our witnesses, basically on a TMZ type outfit.
Okay.
And it's in social media. We've had to put one witness in isolation and protective custody.
All right. I can hear that on the 8th of September.
Aye, sir.
Okay. All right. So I will hear that motion to restrict discovery on the 8th of September. Okay. 9 o'clock.
And Your Honor, in that vein, Kristen Nove on behalf of Mr. Kitchens. Mr. Kitchens objects to the state proceeding via proffer. We want to know what specific threats there are. For example, if something's posted on social media and a witness says, or excuse me, somebody comments, that's ridiculous, somebody should push you off a cliff. That's very different than a direct threat to the witness. So we can do that in camera. We can do that if the court prefers, we can do that in chambers so as not to put the witness's name out there. That's fine, but there have been many allegations that there are threats to witness, and to date, we have received no discovery, not a single shred of discovery of a witness who is actually threatened and evidence of that. So we requested this time that the state produce some witness, some document, some screenshot, something, so that this can be actually verified when we hear this issue.
All right, Mr. Geary.
If these were actual charges, I probably would agree with counsel. They're not. The statute permits us to do an ex parte reveal. We have done that. We would not want to reveal it even to defense counsel, given the danger or potential danger of these witnesses. So the court's aware of what we know at this point in time, as permitted by the statute, and that would respectfully be the plan that we would expect to follow. We don't want to further endanger. I don't know that we will. I made it very clear that I have no information that a particular defendant has either made a threat or arranged for a threat to be made. I don't know how much clearer I can make that. That they want to know who some potential third party is that I can't even identify in all situations, I think is not relevant. I think the threats are out there. We've made the court aware. There's even been a threat to our sheriff and his wife that they would be killed. That one, we identified the perpetrator, and that person is in custody. It is actually a relative of one of our 28 named defendants. The court's aware of that one as well. So we followed the law on that. The law does not address us giving this information if it's not a specifically named charge, and for that, we have not given that information.
Okay, Ms. Novi, I'll take it up when I hear the motion on the 8th. If you have any written or other law or that you'd like to present to the court for my consideration, just please send it to myself and Mr. Kearns, the court staff attorney, prior to the 8th of September, okay?
Thank you, we will.
All right, thank you, madam. All right, anything else on behalf of the state? So I just have the motion to restrict, and I'll take care of that on the 8th of September. Is there any other things that I need to, we haven't gotten the proffers yet. Do we have any other motions outstanding that I need to schedule?
Judge, the only thing we have is that motion to appoint. We've asked C3 to be present so we can ensure defendants have counsel and have enough time with the discovery to prepare for the court's trial date. That's the only thing we have pending right now that we filed. But again, we're going to file the one on the questionnaire and the special set. We're going to file that before the 8th.
We have the court has also inquired about from Miss Bernard and Gina Bernard, that is, and I don't know what the posture is on getting some of these folks attorneys. At this point in time, I have been told that there's a couple of things going on. One, that we have counsel that they're having a difficult time procuring counsel. That'd be the best way I could kind of overarch it. So Is there anything else to add on that issue?
Other than you stand on the motion, Judge. No, sir.
Yeah, the court has just as much a vested interest in getting qualified counsel, but who has not been appointed a lawyer as of yet? Mr. Geary?
If you give us a second, we'll pull that.
Sure.
Address it in a minute.
Yeah, no problem.
Judge, just for clarification, on the motion to no frost, did you grant that?
Yes,
Then we will give you an order for each named defendant. Did you grant the order to adopt all the prior motions and orders from the no frost indictment number?
I did.
Then we will present individual orders on those as well.
Yeah, and I will sign those and we'll give those back to you to be filed in Odyssey, okay? Okay. All right.
We have the names.
Your
Okay.
Honor, I have the names of the unrepresented defendants. Khalif Adams, Damone Blaylock, Cordarius Dorsey, Christian Eppinger, Javon Fleetwood, Demise McMullen, Marvius Nichols, Rogelius Ryan, and Your Honor, I believe